Okay.
Hi everyone, and welcome to this seminar. Today we will be taking you through what happens when a partnership goes wrong. This will be presented by myself and also my colleague Sarah Carr. Just a little bit about me. So my name is Sana. I am a senior solicitor in the team here at BMA Law. I have around 5 years of experience in the healthcare sector, and I've been advising partnerships, GPs and partnerships more specifically, for around 2 years now. I will just hand you over to Sarah so that she can introduce herself.
Hi everyone, and thank you for joining. So my name is Sarah Carr and I'm a trainee solicitor in the BMA Law team. And I've worked for BMA Law for about just over 3 years now. And our main expertise and our area core services is partnerships. So that includes partnership drafting, partnership reviews, advice to partnerships in light of partnership disputes. So we're well equipped to deal with all your queries about partnerships.
So in this seminar today, we are going to take you through 2 examples of scenarios that we've advised on recently. So the first example I will be taking you through, and this will be in relation to where a partner is on long-term sick leave and the partnership currently operate under a unsigned partnership agreement, and we'll just look at some of the issues around that. The second scenario will be, so Sarah will take you through the second scenario, and this will relate to a retiring partner, a slightly difficult exit, and Sarah will also look at the obligations and liabilities that arise in that exit. So, like I said, first of all, I will take you through this unsigned partnership agreement scenario. I'll take you through the background of the circumstances, there's some questions that would normally be asked in these circumstances. I'll take you through the answers that we will give and also how we conclude these circumstances. So the first scenario we have is so in this example, we have a 5-partner practice. We have 5 partners, doctors A to E. In this scenario, Dr. C is on long-term sick leave after having a stroke. The current partners want him to return to work within 12 months, but Dr. C has proposed that he come back with a phased return between 18 and 24 months. Now, how this situation is addressed will depend on the terms agreed between the partners. In this scenario, there are 2 partnership agreements that might be relevant. So first of all, there's an outdated but signed agreement from 2005. This agreement was entered into by doctors A and B and 2 other partners that have now left. The second agreement is a draft but unsigned partnership agreement from 2015. This agreement was made between doctors A, B, and C and another partner that has since left. There are square brackets throughout. This document is not in a final form. It hasn't been signed, but the partners have followed the terms of this agreement and have provided various circumstances and examples by which this partnership agreement has been followed. So that's the background. So in this scenario, as I mentioned, the partnership want the Dr. C to return as soon as possible within 12 months of his sickness. So the questions that the client has asked in this situation is, does the draft 2015 agreement have any legal standing in this scenario? Is the Partnership Act of 1890 applicable? And if so, what does this mean? How can the partnership be dissolved if the partners decide that actually they want to end the partnership? And number 4, could the absent partner be expelled? So first of all, we'll look at the first question. So does the draft 2000 agreement have any legal standing? So the latest relevant authority in relation to partnership agreements is Chima and Jones. So this case looked at pre-existing partnership agreements, and it was held in this case that the terms of a pre-existing partnership agreement will continue to apply where A partner joins a partnership which he knows is governed by certain terms. So in this scenario, did a new partner know that the 2015 agreement applies? B, there is no intention to change the terms of the partnership agreement in light of a new partner joining, or the partners have shown an intention to be bound by the existing terms. So in this scenario, the 2015 agreement. So if these conditions are not satisfied, then a partnership at will is formed, and we'll discuss this in answer to the next question. So in these circumstances, it is not at all clear, and it will depend on the full facts of the case. So first of all, you will need to look at, or we would need to look at, whether all the partners had a copy of the 2015 agreement. Did they know about the 2015 agreement? So you will remember in this scenario that there are 5 partners. D and E joined after, Doctors D and E joined after the 2015 agreement had been prepared. Is there evidence to say that they knew that the 2015 agreement was in existence? Have they been provided with a copy of the 2015 agreement? When they joined, was there any attempt to change the terms of the 2015 agreement? And all of these would be key considerations. So a good starting point would be to look at the communications between the partners and to see whether there is whether it can be determined what the partner's intentions were in those communications. So there is an argument that the partnership agreement is governed by the unsigned 2015 agreement. I mentioned earlier that the partners have provided various circumstances in which a 2015 agreement was followed, although the point is very much arguable either way, so it's not very clear. So the second question is, does the Partnership Act of 1890 apply? What does this mean? So if it is determined, following all the fact finding of the previous question, that there is no applicable partnership agreement, the new partners weren't shown the 2015 agreement, they weren't aware of it, there was attempts to change the terms, then this partnership would be a partnership at will, and the provisions of the Partnership Act would be applicable. So the Partnership Act is very problematic. It's a very old piece of legislation. You can see that by the year 1890. It doesn't take into consideration the intricacies of operating a general medical practice. A partnership at will has certain implications. I won't go into detail about all of these implications, but the ones relevant to this case or this example is that all the decisions are made by a majority agreement. So in this scenario, there would need to be agreement of a simple majority. So that's just 3 of the partners would need to be in agreement of any decision. There are no provisions to account for retirement, expulsion, or suspension. So if the Partnership Act was applicable, if a partner leaves, whether that be voluntary or involuntary, the partnership dissolves automatically, and there is no method by which to approach and aim to resolve partnership disputes, leaving partnership disputes inherently disruptive and very costly. So the third question is, how can the partnership be dissolved? Now, this will depend on which partnership agreement applies. As we've said already, it's not clear which partnership agreement is applicable, whether that be the 2005 agreement, the 2015 agreement, or whether the agreement is a partnership at will. And as I've already said, it will be a question of fact in each case. So if the 2005 agreement is applicable, the agreement contains terms that says that the partnership can be dissolved by unanimous agreement, a deed of dissolution executed by the partners, or a court order. If the 2015 agreement is applicable, then similarly, the partnership can be dissolved by unanimous agreement, a court order, act of parliament, or terminated by NHS England. In the case where the partnership is deemed to be a partnership at will, the partnership can be dissolved by any partner given notice to the other partners of their intention to dissolve the partnership. And in this case, if a partner does give notice to dissolve a partnership, the partnership is dissolved from the date mentioned in the notice as the date of dissolution, or in the absence of a date, from the date of the communication of the notice. So it's very risky to be a partnership at will. As you can see, without agreement, any partner can dissolve the partnership at any time. Other scenarios is the death or bankruptcy of a partner. If anything were to happen to make it unlawful for the business to continue operating, and also by a partner making an application to a court, and the court may decree a dissolution of the partnership where certain grounds have been satisfied. And an example of these grounds is, for example, where a partnership, one of the partners has been incapacitated. So the court has ordered that the partnership should be dissolved. So question 4, can the absent partner be expelled? So this is quite a detailed area, so we'll just look at this. So partners are protected under the Equality Act against discrimination related to a protected characteristic. Disability is a protected characteristic. We know that Dr. C is on long-term sick leave. This may be regarded as a disability. So before the partners decide to expel this partner, they will need to consider the potential of a discrimination claim being brought by Dr. C. So if Dr. C has a disability, there is a duty to make reasonable adjustments to avoid placing Dr. C at a disadvantage. And these adjustments only need to go as far as what is reasonable in the circumstances. In this example, the partners would prefer Dr. C to return to work at full capacity at 12 months. They don't want a phased return to work. So it may be helpful to obtain an occupational health assessment, and this should be followed in order to avoid exposing the partners to allegations of a disability discrimination claim. So importantly, if that occupational health report suggests that a phased return is appropriate, then it would be reasonable to follow the phased return. So Dr. C has a right not to suffer unlawful discrimination on grounds of his disability. For example, being subjected to any harassment or detrimental treatment. So this will also need to be taken into account. It is also unlawful to expel a partner from the partnership on the grounds of disability. So if you do decide to go ahead with the expulsion, you will need to take all of this into account. Being mindful of the fact that Dr. C potentially has a disability, and it is the disability which is the reason that the partners are seeking to expel him from the partnership. Well, if that's proven, Dr. C may seek to argue that he has been expelled from the partnership on discriminatory grounds. So this is obviously not what the partners will want moving forward. They're going to want to avoid any risk and mitigate any risk of receiving a discrimination claim. So before actually expelling a partner, you will need to take all of this into account, and that's why it's important to take legal advice from the beginning. So having considered everything, and if you decide that you still want to expel this partner, you feel that it's not, by expelling the partner, they're not suffering any disadvantage due to a protected characteristic and therefore can't make a discrimination claim, you will then need to look at what the terms of the two partnership agreements, well, the relevant partnership agreement says. So if the 2005 or 2015 agreement is applicable, you will need to look at the precise terms of those agreements. Many agreements will contain specific grounds upon which you can expel a partner, so those terms will need to be followed, including any procedure to suspend the partner first while you investigate, or also to see whether there's any green socks clause where you feel there are no specific grounds within the agreement that are applicable or can be satisfied. If the agreement turns out to be a partnership at will, the partners cannot expel any partner unless there is an express agreement between the partners that confers such a power. So the only way then to expel a partner where the partnership is at will is for all of the partners to agree, and then put that agreement in writing. So if we look at the conclusions of this scenario, so first of all, it's where you have an unsigned partnership agreement that hasn't been properly executed. Not all partners have signed up to the agreement. We have Doctors D and E that have joined since the partnership agreement was drafted. It's not clear which partnership agreement applies, whether that be the 2005 or 2015 agreement, or whether a partnership at will exists. So I think to avoid these situations in future, it's important that each time a partner joins, the partnership agreement is properly updated, it's properly signed and executed. So it isn't enough to receive your final version from your solicitor. You still need to go ahead and make sure the agreement is properly signed and dated. When considering whether to expel a partner, you'll need to look at any potential risks in expelling the partner. In this case, there's a possibility that you might be at risk of a potential discrimination claim on grounds of disability. So we would always recommend getting an occupational health report so that you can familiarize yourself with any reasonable adjustments that can be made before coming to a decision to expel a partner. The occupational health report may also help with the return of the partner. It may then become unnecessary to expel the partner. If the preferred option is that the partner leaves the partnership, it would be ideal if you can get an agreement from him that he voluntarily resigns from the partnership on specific terms. In this scenario, to encourage that partner to agree to voluntarily retire, you may need to offer him some form of financial compensation. And this will need to be recorded in a settlement agreement, and we can advise you on that if necessary. The issue with this is you would need to bear in mind how Dr. C will take the conversations, and whether you don't know what his reaction will be, whether he will take it badly, whether he might bring a discrimination claim out of as a result of that conversation. So any conversation should be handled with care. If Dr. C did leave and the partnership is regarded as a partnership at will, then the partnership would effectively be dissolved. As I've mentioned earlier, under the Partnership Act of 1890, if a partner leaves the partnership is automatically dissolved. So the partnership agreement will need to be reformed with the remaining partners. And in these circumstances, we would recommend a new partnership agreement is entered into in order to continue the partnership. So in all these cases, so in all the scenarios here, we have, firstly, we have discussing whether the partnership will allow Dr. C to remain in the partnership and how to go about their return. If that doesn't go to plan, then the best possible outcome would be to agree a voluntary retirement with compensation. And then moving forward, we would suggest the partnership as constituted after that partner leaves enters into a new partnership agreement. So negotiation is key, but if you feel that you're not able to reach an agreement or the negotiation fails, then mediation can be the most effective way to come to a resolution. So these are all things that we can help you with. I will now hand you over to my colleague, Sarah, who will take you through the second example.
Thanks, Anna. So I will be running you through Partnership B, which looks at a retiring partner and some of the issues that surround his exit and what might make that a bit more difficult than a usual retirement. So I'll be using the same structure as Sana, so we'll look at the background, we'll look at some of the questions that the partnership might ask us in that circumstance, and I'll provide answers to those questions and some advice that we would usually give. And we'll then look to conclude what our general consensus would be on that scenario. So the background to Partnership B is that it's a 4-partner practice. They have a signed valid partnership agreement. It's slightly outdated, but that's not an important fact here because it's been signed and it's valid and it governs the partnership. Dr. X is on sick leave and he has served notice to retire during his time on sick leave. He has asked for an earlier retirement than usual. The partnership agreement stipulates a 3-month notice period, but Dr. X has asked to retire earlier than this date would be. There are a number of liabilities that the partnership owe in terms of debt from NHSPS and overpayments to numerous parties, and these are from the last 5 years which have occurred at the time that the 4 partners were all in practice together. Dr. X is retiring and he doesn't wish to take any responsibility for these liabilities, even though they occurred at the time he was a partner. So the questions that might be asked would be, should we accept Dr. X's retirement early or should we maintain the 3-month notice period? Then we might want to look at how we can avoid releasing Dr. X from his obligations relating to the prior tax years. And the third question would be that this partnership has set aside a lump sum and all 4 partners have contributed to this lump sum in relation to these liabilities. And because the liabilities have not yet been crystallised and no debts have been crystallised, that fund has not been used yet. So the partners might want to know how they can protect Dr. X's contribution of money to this fund. So we'll now deal with the questions. So question 1, should we accept Dr. X's retirement early? So the partners would want to consider the advantages to the partnership if they were to accept this notice period earlier than it would usually be. There should be clauses in the partnership agreement that sufficiently cover a retirement period. So in this case, it was a 3-month notice period. However, there's usually some flexibility, so there might be the inclusion of the wording unless otherwise agreed. So although the partnership agreement does state that the retirement notice period is 3 months, if the partners decide to agree otherwise, then they can either shorten that notice period or lengthen it in some circumstances, depending on what the partners might want to agree. So there is the option there to shorten his notice period. The second thing you might want to consider is, has a locum been engaged to cover Dr. X's sick leave? If so, how long has the locum been contracted to cover for? You'd want to make sure here that it's the most cost-effective and cost-neutral situation for the partnership and Dr. X. So in this circumstances, it would be that Dr. X is on sick leave and the partnership are receiving the NHS reimbursements for this sick leave, and they're using that reimbursement money to pay for a locum to cover Dr. X's sick leave. What you wouldn't want here is for the locum to have been contracted for a certain amount of time and Dr. X to return in that time, because then the NHS reimbursements will cease and you'll still be paying for the cost of the locum. So it's not going to be the most cost-effective way for the partnership to operate. Then you'd have to consider if there are any benefits to Dr. X remaining as a partner for this 3-month notice period. You might want to ask Dr. X and have a discussion with him about his intentions to return to the partnership. Will he be looking to return from sick leave within this time? If so, will it coincide with when the locum has been contracted? If he has no intention to return, you might want to look at finding a more permanent solution. And Dr. X's retirement might then be able to end earlier than it would if we were to disregard the 3-month notice period. If he leaves early, you might want to consider how the workload then might be split between the partners. It's really a commercial decision for the partners to weigh up both the benefit and the risk of what decision they might want to make. So the second question, which is, can we avoid releasing Dr. X from obligations and liabilities relating to prior tax years? So as I've mentioned, this partnership in particular would have had obligations and liabilities and debts relating to prior tax years, and that might include NHS property services and money owed to the CCG in terms of overpayments for aspiration payments. So this is all money that's likely to be owed back, but it hasn't been finalised yet. So what we would do in this instance is we would look at the partnership agreement to see whether there are any clauses which mention how money is dealt with and how debts and liabilities are dealt with in terms of outgoing partners. In this particular scenario, there was a clause in the partnership agreement which states that continuing partners will take over responsibility for all debts and liabilities of the partnership which exist at the date of Dr. X's retirement. Further, the continuing partners will keep the outgoing partner indemnified against such debts and liabilities and all actions, proceedings, costs, claims and demands. So this clause makes it quite clear that it's agreed that Dr. X will have no responsibility for any of these debts which exist at the date of his retirement. So if you are going to agree something different to what this states, it's recommended that this is all documented in writing. If it's not documented in writing, you've got the risk that Dr. X will rely on this clause to say that he's not responsible for any of these debts. Sorry, just to go back there, Sana, onto question 2. Just a final point there is that although the amount of debt hasn't yet been crystallised, there is an argument that these debts and these demands for money all arose at the time that Dr. X was a partner. So although the amount hasn't been finalised yet and is still being negotiated, there is an argument that these invoices and demands for money initially were sent to the partnership at the time that Dr. X was a partner. So there is an argument that he is going to be liable and responsible for these debts. However, we'd have to look more on a fact-finding basis and as to what's been agreed between the partners. As mentioned, if they do want to agree something different, we'd strongly recommend that this is all documented in writing. So the third question, which relates to protecting Dr. X's contribution to this lump sum which has been set aside to pay towards these debts and liabilities. So as you will probably all know, the amounts which are owed subject to change, particularly where NHSBS is concerned. There might be a process of negotiation first in terms of how much the final amount is going to be. So the issue we've got here is that Dr. X is going to be retiring before this amount has been finalised. Now, we'd first look at the facts and try to consider how we can resolve this. So has Dr. X requested the return of his contribution to this fund? Has he asked for this money to be returned to him in his outgoing payments? If he has, we'd want to negotiate with Dr. X and look at some of the options that we might be able to use going forward. So the first option is that you might want to agree with Dr. X that the partnership retains this money that Dr. X has contributed. If once the debt crystallises, it turns out that Dr. X has overpaid, then the partnership retains this excess money. If on the other side we find out that Dr. X is underpaid, then the partnership will bear the risk of paying this shortfall. So in summary of this first option, the partnership bears both the risk and the benefit, and the benefit of paying this excess money, keeping the excess money and paying the shortfall if there is one. Option 2 might be that the partnership retains the money contributed by Dr. X for a set period of time. This could be, for example, 2 years. If the debt crystallises within this 2 years and it turns out that Dr. X is underpaid, there'll be an agreement that he's expected to contribute to this shortfall of the money. If the debt crystallises and Dr. X is overpaid, then the money is returned to him. After 2 years, all the debt is wiped and Dr. X effectively has a clean break from the partnership. The third option would apply if the debt hasn't crystallised or the money hasn't been used in this fund within a certain period. So let's take 2 years, for example, again. The partnership retains this money, and if after 2 years the money hasn't been fully used or all of the debt hasn't yet crystallised, the partnership retains any excess money, but Dr. X is no longer responsible for any of these debts after the 2-year period. So Dr. X has the benefit of not being responsible for any more of these obligations and debts that might arise, but he also isn't entitled to any excess. So Dr. X effectively has a clean break from the partnership, and the partnership gets to retain this money that he's contributed. So just looking at the conclusions now, in terms of the retirement date that we discussed in question 1, we'd want to weigh up the benefit and the risk to the partnership. We'd have to consider all options and try and make it as cost neutral to the partnership as possible. In terms of the liabilities, any agreement made with Dr. X should be in writing with him, and all the terms should be accurately documented to reflect the agreement of both parties. The partnership agreement clause which is in there is slightly problematic though, because it is unlikely that the Dr. X would agree otherwise, and there is no way to compel him to do so. So it may be that you're in a situation where he wishes to rely on that clause. And in that scenario, it would come down to sort of an argument of facts and when these debts arose and when the money was contributed, and that would be something that we would have to look at in more detail. In terms of protecting the money, an agreement should be made in writing to document on what terms the money is being retained. For example, the time periods that I've mentioned, you may want to include those restrictions, and you'd need to make it very clear who's paying the shortfall if there is one, and who's retaining the money if there is excess money once the debt has all crystallised. So you'd look at having a discussion with Dr. X in the first place, just to sort of lay all of this out and look at what the options are, and try and come to an agreement with him that's sort of beneficial for both parties and isn't unfair on either party. It may be that you want to document all of this in a deed of retirement of Dr. X, and this is supplementary to the partnership agreement. With this problematic clause I mentioned, it may be an issue going forward with other partners that look to retire. So in that sense, you might want to draft a deed of variation, which we can assist with, which looks to vary this clause and makes it very clear that the debts which arise at the time you're of a partner, you're still responsible for after your date, or you might still be responsible for a set number of years, like I mentioned, 2 years. It might be that we need to just reword that clause to make it a bit fairer on the partners. There might be an issue with new partners joining in this scenario as well, because the financial situation might be something that deters them with all these debts that are owed. As a new partner, we'd expect that you do a bit of due diligence and look at the financial situation of the partnership before you join. If it's the case that new partners are deterred by this, you'd want to look at making it very clear when the partner's admitted to the partnership. And this might be by way of updating the partnership agreement or by drafting a deed of admission or adherence. And you'd want to look at making it very clear that this new partner is not responsible for any of the debts which arose prior to their admission date. This may remove a barrier that might be preventing new partners from wanting to join the partnership. When you're looking at paying Dr. X's outgoing payment as well, if there are considerable concerns with the current financial situation of the partnership, it might be that the outgoing payment period, which is stated in the agreement, is too short to realistically pay Dr. X his outgoing payment. In that case, you'd want to look at varying that, and that might be by deed of variation, or it could be documented in deed of retirement as well. So these are all just things to consider after the situation with Dr. X is resolved, how you might want to consider documenting all these certain things that you agree. So just to summarise how we can help at BMA Law. So our partnership services, we can advise on circumstances that you might be in currently or any issues that you might foresee. We can advise on dispute resolution mechanisms and what the best way for that might be, and this would include mediation. In terms of drafting documents, we can look at drafting deeds of dissolution, deeds of retirement, settlement agreements if they're needed, and all variations and reviews and amends to partnership agreements, as well as drafting them from scratch as well. So there's a number of things that we can do to help, and alternatively, if you don't think any of those services are what you need, any query that you have, we can assist on and advise what the best way would be going forward. So I think our contact details are on this next slide, and please do let us know if you have any questions for this seminar, or alternatively, please take a note of our contact details on the screen and then forward any queries which you might have to us. As mentioned, these are just two of the scenarios that Sana and I have gone through today, and we do get a number of scenarios that come in that we're happy to advise on and assist you and support you with. So thank you for listening, and if you have any questions, I think they will be read out to us now.
Yep, I'm just going to go straight into it if that's okay with you.
Yeah, of course.
So I'm leaving my current partnership and the remaining partners want to hold on to the money in my current account until a year from my leaving date. I think that is too long and not reasonable. How could I challenge this?
Do you want me to take this one, Sana, or? I think you're on mute, sorry.
Yeah, sorry, I've muted myself so as to not disturb Sarah's presentation. But in answer to your question, well, the first place would be to check the partnership agreement to see what it says. So there's normally a clause that will be entitled something along the lines of payments to outgoing partners. In that clause, there'll be a term that states the time period in which an outgoing partner should be paid. If this is longer than that term, if the 1 year is longer than the term of the agreement, then you can argue it. If it's as stated in the agreement, the alternative would be to reach a compromise. So have a discussion with the partners, understand their reasons why, explain the reasons why you don't want to wait that long, and see if you can reach an amicable agreement. Any agreement that you decide upon should always be recorded in writing to avoid any disputes in the future. So in summary, it's just checking the partnership agreement to see what the terms are relating to time periods. If there's any variation in what the partners are proposing and what the partnership agreement says, then that variation would need to be agreed. If you don't agree to that variation, then it's a case of having a discussion with them, weighing up the pros and cons, and considering whether you can come to an amicable agreement. In the event of a variation and an agreement, you would need to record the details of that agreement in writing to avoid any dispute arising in the future.
Thank you, Sana. If doctors D and E agreed that the 2015 agreement is okay, even though they haven't signed it, could it still be applicable?
So in that scenario, it's a question of fact. So it would need to be at the time they joined the partnership, did they see the agreement? And if they said, fine, that's great, let's operate on the terms of that agreement, then yes, there's an argument that the 2015 agreement is applicable, but it's arguable either way. So if it's one person's word against the other about how the relationship came about, then it's a very grey area. And we always recommend that when a new partner joins, the partnership agreement is either updated or those partners enter into a document that's known as a deed of adherence to avoid these types of issues. Because like I said, I think we touched on the fact that it is a question of fact, and if there's any dispute around the circumstances of those facts, then we're entering into a very ambiguous territory.
Where can I get a copy of the CHIMA decision? Can you help me understand more about what this could mean for my partnership, please?
Sarah, do you want to pick that one up?
I think you should be able to get sort of a summary of it online just by searching. If you try an online search, if you wanted more specific advice on that decision and what that might mean, then do please contact us and we can assist you with that and look at how that decision might affect your current situation in the partnership. But as I say, there should be a copy online somewhere. It may not be a full detailed summary, but it should be a brief summary of the case and sort of what that says. There'll also be a recording of this seminar posted after. So if you wanted to go back and watch Sana's explanation about the CHIMA and Jones case summary, then that will be posted as well after.
Yeah, and if you contact one of us directly, we can provide you with more specific advice in relation to that. There will also be lots of articles and commentary online, so a lot of there may even be commentary on our website. But if you drop us an email, we can cover that more specifically.
In the absence of an agreement and the partnership is operating at will, would a partnership dispute have to be dealt with in the courts?
Not necessarily, no. So if you're a partnership at will and there's a dispute, it depends sort of what avenue you'd be looking to go down. If it's something that can be resolved by negotiation, then there wouldn't be any need to go to the courts for that. It may be that something escalates to the courts, but we would want to try and help you avoid that because it's quite costly for the partnership. It may be that something is more appropriate, like mediation. Just because you don't have a partnership agreement doesn't mean things like mediation won't work for you.
It's unclear to us if an agreement is in place, as we have numerous documents signed by some of the partners, though not all, and a draft unsigned declaration of trust which covers off the premises. Can you provide us with advice about our position and what we need to do to make sure we are protected?
So in this scenario, I would suggest finalising, reviewing the agreements to make sure that that all the partners agree. Updating the agreement to cover any new partnership agreements. If the agreement is really outdated, so I'm referring to the partnership agreement, then it may be best to just go ahead with a fresh document, a standalone document where all the terms are set out in one agreement, and enter into a new partnership agreement. The declaration of trust really should be looked at as well to make sure that all the partners that should be signed up to the declaration of trust is within that document as a party. and then moving forwards, ensuring that it's been validly signed to ensure that it's enforceable.
In a 2GP partnership at will, if one retires but not variated the contract to that effect, what can the remaining partner do?
So if there's a two-partner practice and one has retired, and he hasn't varied, does it say he hasn't varied the contract?
Yeah, correct.
So in terms of varying the contract, I'm not sure whether you mean the partnership agreement or the core contract. In terms of the partnership agreement, when a partner retires, it doesn't necessarily mean the partnership agreement has to be updated. We'd expect a well-drafted partnership agreement to cover off all provisions relating to retirement. In terms of varying the core contract, that's something that I think you need permission from the CCG on, to get permission to be a sole practitioner. So that would be something that we could look at in more detail for you. But really that's something in more detail we'd have to look at on what communication has been about getting permission to have that contract to be held in the name of a sole practitioner.
Does the partnership agreement need to be sent back to the lawyers when any new partner joins?
It doesn't need to be sent back when a partner joins, but as Sana's mentioned, when a partner does join, we'd recommend your partnership agreement is updated to account for this change. Otherwise, there's a potential risk of you being a partnership at will. So if you do need that updating, do send it to us and we can look at updating that for you. But there's no need to do that unless you have the intentions of updating the partnership agreement. But as we've mentioned, we would recommend that it is updated to account for a change like that.
Does the BMA offer mediation services to help with disputes?
Yeah, so the BMA offer mediation services as part of your membership, so you can access that online via the BMA website.
Under what circumstances can NHS England terminate a partnership, and does this apply to NHS Wales as well?
Sorry, can you say that question again?
Under what circumstances can NHS England terminate a partnership, and does it apply to NHS Wales as well?
So the circumstances upon which a GMS contract can be terminated are set out in the GMS contract. So there are various circumstances. One circumstance in which the partnership is at risk of losing their GMS contract is if the GMS contract is held by a partnership, but that partnership agreement, the partnership entity is subsequently dissolved. So there is a risk in that scenario that you might lose your GMS contract. So it's important to inform the CCG or the health board of any changes to the partnership, and also making sure if you're based in England that your CQC registration is kept up to date as well. If you go from a partnership registration to a sole provider, you need to completely apply as a new provider as the sole contractor. There are various other reasons why a GMS contract can be terminated. So one will be, so just two examples off the top of my head, is that if the contractor dies, you can lose the partnership. So you can lose the GMS contract in the event that there's a sole contractor because it hasn't passed to another partner. So that's another way you can keep the GMS contract safe, is by holding it in partnership. And if there was a sole contractor and that sole contractor became mentally incapacitated, there's another way in which you can lose the GMS contract.
How often should a partnership agreement be updated if the partnership itself doesn't change for many years?
I think that's arguable. It would depend on how well drafted your current partnership agreement is and how many changes there's been to general practice over the last number of years. So we recently updated our partnership agreements last year to account for primary care networks, the clinical negligence scheme, and the new to partnership payment scheme. So things like that won't be in your current agreement if it's not been updated for a number of years. It's still a valid partnership, of course, because if it's still the same partnership that's been operating together for that number of years, then there's no reason that it wouldn't be valid. It's just that it might be quite outdated and not taken into account any of the recent changes to general practice. In terms of how often it should be updated, it's difficult to say. As I say, it would depend on how well drafted it was in the first place, but I'd say probably every couple of years, just to make sure that all the changes to general practice can be documented. If it's not a case that it needs to be updated, then we also have a review service where we can look at just reviewing your partnership agreement and providing you with advice on any clauses that we think are outdated that might need changing, and we can provide you with certain recommendations for changes of specific clauses.
Who has the cost of any dispute, court fees, etc.? Is it the partnership cost taken into account in the final settlement, or the GP who will not agree?
I think that would depend what your partnership agreement says. Sometimes we often find there's a clause which states who will bear the cost of any dispute. If there is a dispute, it might be that it states in your partnership agreement that it's borne by the partnership, or it might be a clause that states that it's borne by the partner bringing the dispute. So that'd be something you'd need to look at in more detail in your partnership agreement.
Yeah, just to add there as well, if the dispute goes as far as court proceedings, the judge may issue directions as to costs. So it might depend in that circumstance what the judge's order states as well as to who will bear those costs.
Thank you. And if partnership agreement is signed but a partner has left, will this become a partnership at will if not updated, or will it remain as a partnership agreement with the retired partner still bound under the agreement terms?
So if you have an existing partnership agreement where a partnership has left, if your partnership agreement provides for the retirement of a partner, then that's fine. The procedure should be followed in relation to that partner. The partnership agreement should also set out that outgoing partner's obligations and liabilities. So even though that partner is signed up to the partnership agreement, they may not be bound by all of the terms in the partnership agreement by virtue of them being an outgoing partner. The partnership agreement we would expect to see it specify what terms relate to outgoing partners. And normally when a partner leaves, there will be clauses, for example, payments to outgoing partners that the partnership will need to follow. There might be liabilities and indemnities applicable to the outgoing partner, and restrictions on their future activities to protect the interest of the partnership, and they would be liable to continue meeting their obligations under those clauses. And provided a new partner doesn't join, that partnership agreement will remain valid. If a new partner does join and you want that partner to sign up to the existing partnership agreement, then that can be done by updating the agreement. And normally when a new partner joins, it's a good time to remove partners that have retired. So the partnership doesn't necessarily need to be updated when a partner retires, as long as the existing partnership agreement provides adequate terms to cover that that partner's retirement.
And lastly, it's not a question, just a comment. Thank you for a helpful presentation. That's all the questions I have for you guys.
Thank you for attending, everyone.
Thanks everyone for joining.